The courtroom was unusually quiet as cameras began rolling, capturing the moment two sharply different judicial philosophies were about to collide. On one side stood Judge Frank Caprio, widely known for his compassionate rulings and his belief that justice must be both lawful and humane. On the other stood Judge David Fleischer, a strict constitutionalist whose focus on uniformity and equal application of the law had earned him respect among traditionalists. Their debate topic was deceptively simple but morally explosive. Should poor people get special treatment in court? Before we dive into this powerful courtroom clash, make sure you like, subscribe, and share, because today's debate will challenge everything you think you know about justice, fairness, and compassion in the courtroom. Caprio began in his warm, measured tone, polite, steady, but filled with conviction. The audience leaned forward, accustomed to his famous ability to humanize even the simplest legal violation. Caprio argued that poverty was not merely a financial status, but a structural disadvantage that often determined whether someone could comply with the law in the first place. When a poor mother gets a parking ticket because she works 2 jobs and can't afford a private garage, Caprio explained, the issue is not irresponsibility but circumstance. When a struggling immigrant can't pay a fine, the choice becomes unfairly skewed between feeding their family and following the rules. His belief was not that poor individuals should escape accountability, but that justice should adapt to context. If the goal of the system is rehabilitation, fairness, and societal progress, then the court must understand why violations occur. Compassion is not favoritism, Caprio exclaimed. It is a recognition of reality. Across from him, Judge Fleischer listened carefully, but his expression remained firm, almost unmoved. When it was his turn to speak, he opened with a fundamental premise of his judicial philosophy. The law must treat everyone the same. To Fleischer, acknowledging poverty through altered sentencing was equivalent to bending rules based on personal characteristics. He warned that once socioeconomic status becomes a factor, the entire legal system risks sliding down a slope that blurs the boundaries between justice and preferential treatment. If poor people get leniency because of their poverty, he argued, then should wealthy people get harsher punishments because of their wealth? Fleischer emphasized that justice is blind for a reason. The moment judges begin deciding who deserves more compassion or more punishment, objectivity diminishes. For him, equality meant sameness, and sameness was the only path to fairness. Caprio countered with a story. An elderly man who once appeared before him with a stack of unpaid tickets. The man explained he had to choose daily between medication and parking payments. Caprio had reduced the fines drastically and even publicly expressed admiration for the man's perseverance. Was that favoritism, he asked, or was it justice shaped by humanity? Fleischer responded with a sharp distinction. Individual empathy cannot override systemic consistency. He recognized the emotional power of such stories, but warned that courts cannot operate on emotion alone. If every judge follows their feelings, he said, the law becomes unpredictable, unstable, and unequal. Caprio disagreed. He insisted that predictability without humanity becomes cruelty dressed as fairness. He emphasized that poverty directly influences behavior and opportunity, and the court's duty is not punishment alone but understanding the underlying causes. With the audience divided, the tension grew thicker. The debate turned toward the meaning of justice itself. Caprio believed justice must reflect the human condition. Fleischer believed justice must transcend it. They examined how fines disproportionately affect the poor. For a wealthy person, a $100 ticket is an inconvenience. For someone earning minimum wage, it may represent a week of groceries. Caprio argued this imbalance means the punishment is not equal at all. What appears to be the same fine is actually vastly different in impact. Fleischer acknowledged the imbalance but offered a different solution. Reform the penalty structure legislatively. Don't leave it to judges to compensate for flawed systems. He saw Caprio's approach as patchwork justice, compassionate but inconsistent. If the law is unfair, Fleischer said, change the law, don't rewrite it from the bench. Caprio insisted that waiting for legislative fixes leaves millions suffering in the meantime. We cannot ignore human suffering because paperwork is pending. He said, judges were given discretion for a reason. As the first part of the debate ended, the philosophical divide became unmistakably clear. Caprio stood for adaptive justice that responds to the nuances of life. Fleischer stood for equal justice that refuses to bend, even for noble reasons. The audience could already sense that the next phase of this clash would dig even deeper into the ethical and legal core of what makes a courtroom fair. The second segment opens like a scalpel. Both judges move from philosophy into mechanism. The stage now is not abstract fairness but the real-world consequences of choosing one model of justice over another. Where the first part sketched broad principles, Caprio's adaptive compassion versus Fleischer's strict uniformity, this deepened section dissects how each philosophy plays out in practice, who benefits, who risks harm, and where the legal system either corrects or compounds social inequities. Caprio begins by reframing the problem through procedure and outcomes. He does not deny that law's language is neutral. Rather, he insists neutrality in text does not translate into neutrality in effect. Caprio walks the audience through concrete case types: unpaid parking tickets, failure to appear for court because of unpaid child care, inability to post bail, or fines that compound into warrants. He argues that these are not edge cases. They are systemic levers that push marginalized people deeper into instability. The procedural machinery of courts, default hearings, automated fines, arrest warrants for unpaid minor offenses, interacts with poverty in predictable, harmful ways. For Caprio, justice must be measured by outcome as much as by doctrine. If courtroom procedures disproportionately produce negative life outcomes for the poor, then unchanged procedures are, in effect, unjust. He details how discretion works as a corrective. Judges can convert fines into community service, stagger payments, waive fees, or provide access to social services. Caprio frames judicial discretion not as caprice but as triage, a way to prevent a minor citation from cascading into loss of employment, housing, or immigration consequences. He cites examples anecdotal but illustrative: a single missed court date that leads to a bench warrant, job loss, and a cycle of deeper legal trouble. Those domino effects, Caprio says, show that equal on paper, justice often equals unequal in life. Fleischer answers by shifting from anecdote to principle and predictability. He does not dismiss the human stories. He acknowledges them with gravitas. His worry is institutional. Once judges begin to factor socioeconomic status openly, they risk creating variable standards that depend on the temperament of the judge, the resources of the court, or the advocacy available. Fleischer draws attention to two dangers. First, selective mercy, where some poor defendants receive leniency while others do not, producing arbitrariness. Second, legal erosion, where precedent built on compassion becomes a pathway for subjective interpretations that could ultimately undermine rule-bound governance. He pushes a technical objection. Where do you draw the line? Fleischer asks whether poverty should be the only mitigating factor. What about addiction, mental illness, or cultural context? If judges make holistic assessments without legislated criteria, the outcomes may be humane but inconsistent. He worries about the structural integrity of legal standards when individualized mercy becomes an informal norm. For Fleischer, the cure should be institutional reform, not ad hoc judicial adjustments. He proposes legislated tools like income-based fines or formal diversion programs codified by statute, where discretion is circumscribed by clear rules. Caprio responds with a hybrid pragmatism. He concedes that ad hoc mercy without guidelines is vulnerable to inconsistency, yet he argues the absence of ideal legislation does not excuse continued harm. Judges will confront poor defendants today. Legislative perfectibility is a slow process. Caprio advocates calibrated discretion, judicial use of standardized assessment protocols, financial affidavit forms, mandatory consideration of ability to pay, checklists for diversion eligibility, to guide decisions. In his vision, discretion is not unbounded. It operates within frameworks designed to reduce arbitrary outcomes. He imagines a courtroom where compassion is institutionalized through consistent processes, uniform forms, training for judges about socioeconomic impact, and recorded rationales so that decisions can be audited. Fleischer accepts the logic of structured discretion as far as it goes, but he reiterates his red line: lawful predictability must be primary. He suggests alternative institutional solutions that keep standards coherent. Sliding scale fines set by statute, often called day fines, mandatory diversion programs for specified low offenses, and publicly funded representation for indigent defendants. The key difference is locus of authority. Fleischer trusts democratically enacted reform over individual judicial improvisation, because the former allows public input, legislative debate, and clearer appeals routes. In his view, courts are not the ideal shop for social engineering. They should implement reforms, not create them. The middle of the debate turns empirical. Caprio invokes studies and aggregated data, translated into accessible narrative, showing that jurisdictions with judicially enabled diversion and payment plans often see reduced recidivism and lower administrative costs. He argues that compassion can be economically rational. Court resources are wasted processing repeated defaults, and arrests for unpaid fines create additional costs. Caprio frames humane discretion as not merely moral but efficient. Fleischer counters with cautionary empirical hypotheticals. If discretion becomes widespread without statutory guardrails, citizens could perceive favoritism and lose confidence in legal institutions. He emphasizes the importance of perceived fairness, not merely aggregate outcomes. If the public believes rules are applied unevenly, compliance may fall. By the close of this part, both judges converge on practicalities even as they preserve their core divides. Caprio insists on structured discretion, standardized forms, training, and documentation to channel compassion into consistent outcomes. Fleischer presses for legislative architecture, sliding fines, codified diversion paths, and robust public defense that maintain predictable, equal application while acknowledging socioeconomic realities. The real battleground becomes implementation. Who builds the frameworks that prevent arbitrary mercy and entrenched inequality? Caprio trusts the lived, immediate corrective power of judges guided by clear processes. Fleischer trusts legislatures to craft equitable systems and sees judges as the implementers rather than the originators. Both paint realistic reform agendas. They disagree only on the primary actor. This segment reframes the debate from philosophy to governance. The tension is not between compassion and lawlessness, but between judicially administered, process-oriented compassion and statutorily mandated, system-level reform. Each approach has trade-offs. Caprio's offers immediacy and humanity. Fleischer's offers uniformity and democratic legitimacy. The question left hanging is not whether poor people's circumstances matter, both say yes, but which institutional lever is safer and more effective for translating that recognition into fair legal outcomes. Can the court system preserve the rule of law while responding constructively to poverty? Here both judges strip away rhetorical armor and attempt to prescribe concrete, implementable reforms that address their critics' core concerns. The tone is less adversarial and more architectonic. They draft a policy ecosystem rather than wage another philosophical duel. Caprio opens with the courtroom as a human services node. He argues that modern courts already do social work. They adjudicate housing disputes, child support, and small claims. So why not explicitly integrate social mitigation when criminal penalties would perpetuate harm? His plan is modular and practical. Standardized indigency assessments at intake, mandatory consideration of ability to pay for fines, automatic eligibility checks for diversion programs, and clear documentation requirements so decisions are reviewable. Caprio stresses training. Judges and clerks should receive instruction on socioeconomic risk factors and on avoiding implicit biases. He imagines integrated court teams, social workers, legal navigators, and financial counselors, collaborating to convert many punitive outcomes into restorative solutions. Fleischer nods appreciatively to the idea of process integrity, but insists on legislative scaffolding. He proposes statutory templates for sliding, scale fines calibrated by income and family burden, mandatory diversion for enumerated low-level offenses, and stronger legal aid funding to ensure equal advocacy. Fleischer presses for transparency mechanisms. Every deviation from standard penalties must be documented with a textual rationale available to appellate review. He argues that when the legislature sets the range, judges may exercise discretion within a democratically legitimized band, reducing arbitrary outcomes while allowing case-by-case adjustments. Both judges now converge on specific policy tools, though their emphases differ. Day fines/sliding scale fines. Caprio supports them as a useful statutory tool. Fleischer insists they must be enacted by legislatures to ensure uniformity. They agree such fines more equitably calibrate punishment to ability. Diversion and restorative options. Both endorse community service, restitution where appropriate, and rehabilitation programs as alternatives to cash penalties. Caprio emphasizes judicial discretion to route defendants into services. Fleischer wants those diversion criteria codified. Ability to pay assessments. Both believe rulings should consider defendants' financial reality. Caprio wants immediate judicial use of assessments. Fleischer wants standardized statutory assessment forms used uniformly across jurisdictions. Public defense and access to counsel. Fleischer champions scaling funding for public defenders as central to fairness. Caprio agrees and adds that counsel helps courts understand life context, thereby making better decisions. Data and auditing both demand data transparency. Caprio believes tracking outcomes will show which discretionary practices work. Fleischer views data as the safeguard against unchecked mercy. They agree audits and public reporting will increase accountability and trust. Their parting arguments focus on the political and moral calculus of change. Caprio insists that change must not be a rhetorical promise, but an operational reality in every courtroom today. He argues for pilot programs and administrative rules that can be implemented by chief judges and court administrators, even while statutory reforms are pursued. Fleischer counters that pilots are valuable but must sit within a framework that preserves consistency and public confidence. Only legislation can provide that stability. They trade their final, albeit different, visions of an aspirational court. Caprio pictures a justice system that treats punishments proportionally not just in legal terms, but in human terms. A system where a fine does not translate into a life-crushing penalty. Fleischer pictures a justice system where reforms are transparent, democratically accountable, and uniformly applied so that the public can trust law remains blind yet fair. The debate ends with a pragmatic reconciliation rather than an unresolved standoff. Both judges acknowledge the need for a multi-pronged approach: immediate administrative reforms to mitigate current harms, statutory reforms to create uniformity, and long-term investments in legal aid and social infrastructure to address root causes. The final insight is modest but powerful. Justice requires both compassion and structure. One without the other risks either arbitrariness or cruelty. In the end, the disagreement is not about whether poverty should influence justice. Both judges agree it must be considered, but about how to incorporate that consideration without undermining legal predictability. The most durable answer likely lies in a hybrid: legislated standards that create equitable baselines, sliding fines, mandatory diversion categories, coupled with structured judicial discretion, guided by standardized assessments and rigorous documentation. That model preserves the rule of law while recognizing the moral imperative to prevent punishment from becoming a cycle of deprivation. Their closing exchange is less combative and more collaborative. Each judge offers to work with legislators, court administrators, and social service providers to translate these shared principles into practice. It's a rare judicial détente, born from the admission that law, at its best, protects both the letter of the rule and the dignity of the person bound by it.